Welcome all of our witnesses today, and thank you for being here this morning. And Mr. Koo, you are now recognized for your opening remarks.
Thank you, Mr. Chairman. Thank you, Mr. Ranking Member and members of this committee. I appreciate the opportunity to testify about the People's Republic of China's use of lawfare against Taiwan. My central point is this: the People's Republic of China is using law not merely to justify force, but to substitute for it. Through legal and quasi-legal means, Beijing is attempting to coerce Taiwan, its supporters, and even foreign nationals, even U.S. citizens, below the threshold of armed conflict. If U.S. policy focuses only on deterring invasion, it will miss how Beijing is already changing the status quo against Taiwan and in its favor. Lawfare is the strategic use of legal rules, institutions, and processes to achieve political and military objectives. While the term emerged in U.S. debates during the war on terrorism, it has long been incorporated into Chinese military doctrine. A defining feature of contemporary PRC lawfare is asymmetry. Beijing exploits the openness and independence of foreign legal systems like the United States, as well as international institutions, while remaining largely insulated from reciprocal legal pressure at home. This matters for Taiwan because PLA doctrine does not treat war and peace as binary states. Instead, it emphasizes continuous struggle across legal, political, economic, and psychological domains. Within that framework, lawfare is not merely preparatory to military action, it can be a substitute for it. If Beijing can constrain Taiwan's international participation, delegitimize its democratic institutions, intimidate its leadership in civil society, and deter foreign engagement through legal pressure, it can achieve its strategic objectives without firing a shot. Ignoring these tactics, because they are non-military, concedes a critical domain of competition. Most prominently, the PRC persistently mischaracterizes international law by claiming that UN General Assembly 2758 resolves the questions of Taiwan's sovereignty. In fact, as this Congress has recognized, the resolution addressed only which government would represent China at the United Nations. It did not determine Taiwan's international legal status. Nevertheless, through sustained legal pressure and other diplomatic campaigns, Beijing has induced UN bodies and affiliated organizations to treat Taiwan as, quote, a province of China, purely as a matter of administrative practice, but which has transformed a contested legal claim into a bureaucratic norm. Similarly, the PRC asserts that its One China principle is a binding rule of international law, which conflates diplomatic recognition with legal obligation, and it categorically rejects the applicability of the principle of self-determination to the people of Taiwan, claiming the people of Taiwan are not, quote, a people. PRC domestic law reinforces this strategy. Most recently, PRC authorities have expanded criminal liability for so-called Taiwan independence activities through judicial interpretations and policy documents. These measures criminalize mere political advocacy, including speech occurring entirely outside of the PRC, and explicitly asserts extraterritorial jurisdiction. These are not empty threats. PRC authorities have issued arrest warrants, wanted notices, and imposed sanctions against Taiwanese officials, political leaders, and online influencers for conduct occurring wholly outside of China. These actions serve classic lawfare functions. They intimidate civil society in Taiwan and delegitimize Taiwan's democratic leadership. PRC law also targets foreign nationals who support Taiwan or oppose China. As a leading scholar of Chinese law has observed, it is difficult to avoid the conclusion, if you analyze Chinese law, that, quote, any advocacy of Taiwan independence or support for Taiwan by anyone, anywhere, can be treated as a criminal offense under PRC law. My comments just now could be a criminal offense under PRC law. Even if it's unenforceable, it can impose reputational and professional costs and chill lawful and necessary speech. I conclude with recommendations for how the U.S. can respond. First, the U.S. should reaffirm publicly and clearly that Taiwan's international legal status has not been resolved under international law, and that the PRC is mischaracterizing Resolution 2758. The U.S. should use this diplomatic pressure to ensure that international institutions stop referring to China stop referring to Taiwan as a, quote, province of China, even if it's just for administrative purposes. And the U.S. should refuse cooperation with PRC legal actions that target Taiwan's democratic governance. And even more importantly, it needs to work to push allies to refuse any cooperation with PRC law enforcement authorities. And finally, it needs to ensure that court judgments from the People's Republic of China, which form part of its coercive political strategy, are not recognized or enforced in U.S. federal or state courts. To conclude, we must remember that effective deterrence must deny not only invasion, but coercive success below the threshold of armed conflict. Recognizing and countering the PRC's asymmetric lawfare is essential to preserving stability in the Taiwan Strait. Thank you, Mr. Chairman.